.9. I'm Ruby Susan, joined by Sarah Ramantanis, and we're now speaking with Senator David Leyonhelm from New South Wales for the Liberal Democrats. Thank you so much for joining us today, David.
Hello.
So we're speaking today about Article 18C, which has been seeing a lot of news attention since Senator Corey Bernardi came forward and pledged that he would be introducing the bill in government. Now, since then, a number of senators, yourself included, have signed in on support of the bill. Why are you supporting this current action?
Well, I supported, in fact, I co-sponsored the bill in the last Parliament that Senator Bob Day introduced, which had exactly the same terms as the one that Senator Bernardi has now introduced. I also plan to introduce another bill of my own, which will be to repeal Section 18C entirely, as well as all the ancillary sections that go with it. So, in other words, it simply won't exist under my bill. Mm-hmm. So, the reason for all that is that I'm a Libertarian. The Liberal Democrats is a Libertarian party, and free speech is fundamental to liberty. It's the right that if you don't have free speech, you can't defend your other rights, your right to worship, your right to assembly, your right to a fair trial and equality before the law and those sorts of things. You cannot defend those rights if you don't have free speech. It's fundamental to a free society. And Section 18C encroaches on free speech. Mm-hmm. And in my view and the view of my party and my supporters, it has to go.
I'm going to bring up now Section 18D, which is basically the exemptions from Article 18C, such as Section 18C does not render unlawful anything said or done reasonably and in good faith in performance, exhibition or distribution of artistic work, in the course of any statement, publication, discussion or debate made or held for genuine academic, artistic or scientific purpose, or any other genuine purpose, in making or publishing, or in a fair, accurate report of any event or matter of public interest, or a fair comment. So I suppose with these exemptions that already do exist, what exactly do you believe is currently being impeded by our racial discrimination laws that is not covered, that would be able to be said if we did repeal 18C? Could you give me an example?
Yes. Racial abuse, colour-based abuse, ethnic abuse, national origin abuse is not fair comment. I mean, the defence of 18D is essentially fair comment. Mm-hmm. And so therefore, an academic article with references or even an article in a newspaper, a commentary in a newspaper that didn't go over the top would be able to rely on that defence of 18D, but abuse would not. And my argument is, of course, that when Mark Kenny abused me in his piece in one of the Fairfax papers, mm-hmm. He would not be able to rely on 18D because he went beyond fair comment. Now, my argument is that you should be able to abuse people. You should be able to be as rude as you like, in words only, about people on the basis of their race, their colour, their national or ethnic origin. Mm-hmm. And having been abusive like that, and we don't have to approve of what they say, we don't have to like what they say, we don't have to voluntarily listen to what they say, but only by allowing people to say those things can we then vigorously rebut them, and if necessary, with abuse. This is how ideas are challenged. This is the marketplace of ideas, if you like, so that...
So these ideas couldn't be put forward without abusive language?
No, well, it doesn't really matter whether it's abusive or not. If people have those attitudes that would lead them to become abusive, telling them that they can't be abusive is not going to change their attitudes. And underlying it all, we don't want people to have racist attitudes, but suppressing their speech is not going to change those racist attitudes. And the old saying is, sunlight is the best disinfectant. Allow people to express their bigoted, racist views and challenge them with more reasoned, more rational, but equally vigorous views, so that they are exposed. They'll either change their views or realise that they are well out of step with the community and will not feel tempted to put anymore.
So what, under our current laws, including Article 18D, do you feel people are being unfairly prevented from doing or saying?
Well, the 3 students who are being pursued in the Human Rights Commission as a result of incidents that occurred at the Queensland University of Technology are absolutely being victims of this law. And do
you believe the teacher who's now been out of work for 3 years is also a victim of these circumstances?
No, that's her choice. She's not working as a consequence of 18C or 18D. She's decided, and the university has apparently gone along with it, that having initiated a complaint against 3 students, now she's feeling stressed and therefore she can't work. Now, that's really a different issue altogether. I mean, there are times when I'd like to feel so stressed that I didn't have to work for 3 years but could get paid too. And I dare say many of us could think of situations where we might do that. What we're talking about here, though, is those 3 students who made comments on Facebook, which were subsequently taken down, as I understand it, who have been pursued through the courts over 3 years. And those comments, I mean, I would absolutely argue that they were not even offensive under 18C, let alone 18D, and yet they have been pursued. Now, that's not the way that free speech is supposed to work. Free speech should not cost you hundreds of thousands of dollars in legal fees, even if they come out at the other end exonerated, which I anticipate will be the case.
Now, Section 26 of the Racial Discrimination Act makes it clear that an offence to do an act that is unlawful is not necessarily a criminal offence. So these are not criminal charges that are being brought for people who do break the discrimination laws. So with freedom of speech, in the case of the students, they went forward and said what they had to say, and it was based on what they said that these consequences are happening. Now, isn't the freedom of speech the prevention of them being able to say it at all?
I think you're a bit confused in your argument there. If it's going to cost you hundreds of thousands of dollars of legal fees, it doesn't really make any difference whether it's a criminal or a civil jurisdiction. It's still costing you hundreds of thousands of dollars in legal fees. If you are exposed to some sort of legal consequences for speaking, just for speaking, then that is an impediment on your freedom of speech. Now, we do have impediments on freedom of speech in this country and most civil common law jurisdictions where infringements on freedom of speech are agreed, are accepted. They include such things as incitement to commit a criminal offence and defamation. They are not in question here. 18C is all about feelings. I feel insulted, offended, humiliated, and so forth. The law is being invoked in order to protect people from those feelings.
The Human Rights Commission has come forward and said that for a case to be followed up, it does need to pass that of any reasonable person would feel that way in that condition. So in the case of the 3 students, the Human Rights Commission has decided that any person in the teacher's position would have felt similarly. Now, obviously, you feel differently about that. However, do you feel that Australia has an issue with racial discrimination?
Yes, it does. There are 2 provisions in the Constitution which are specific to Aborigines, and so yes, I regard the Constitution as racist until they are removed.
There have been a lot of studies that have found direct correlation between people who are subjected to racial abuse or abuse based on differences, either sexuality or gender differences, that shows that they are much more likely to develop mental illness, which then, of course, can affect future job hunting and job prospects and affect quality of life. Knowing that abuse can have a direct effect on the people who are being abused, do you think that there's a bit of a weighting up as to who would actually receive abuse if Article 18C was removed entirely? Do you think that it's really fair to say that having that abuse aired will not harm people?
Well, first of all, your proposition that mental illness can arise from racial abuse is highly disputed. I just don't accept that. Mental illness is a disease. It's sort of like getting cancer can be caused by being abused by your wife or something like that.
The links between things like bullying and mental illness have been, discussed emphatically for the last 5 years. There have been a lot of correlations found between treatment of people.
You can discuss it as emphatically as you like. It doesn't make it true, I think, until there is mental illness is an illness, and it needs to be treated like an illness, and to blame somebody else for an illness of that kind, I think, is fanciful. But the other aspect of your question is a suggestion that people who are not white, living in a predominantly white society, as we are less able to cope with the slings and arrows of normal life than white people are. Now, that in itself is a racist assumption.
That was you're mixing my words. I'm saying that they're more likely to receive the slings and arrows, and they would receive more of them than white people do. That's what I'm saying. Not that they are less able to cope, but they receive more.
And therefore they become mentally ill.
I'm saying it's possible to lead towards mental illness.
Good luck with that proposition.
Beyond Blue's published quite a few studies about the links between that, but we are free to disagree.
If Article 18C isn't the answer, Senator, what do you propose we can do to end racial discrimination in Australia?
As I have said, sunlight is the best disinfectant. Racial discrimination in effect is already illegal under the Racial Discrimination Act, and nobody is proposing that the Racial Discrimination Act be abolished.
Yeah.
What we're talking about here is speech, and it's feelings. It's people's feelings. Now, the law can deal with things like fraud, theft, property damage, property harm, and assault, physical damage. It should not be involved in feelings. Our feelings are our own. Nobody forces us to love somebody, hate somebody, feel disgust. Equally, nobody forces us to feel insult or offence, and the law should stay out of it. It's a private matter. Whether or not it's rational or subjective or objective is not material. It's not a matter for the law.
That was Senator Leyonhelm from New South Wales with the Liberal Democrats. Thank you so much for joining us here on The Informer.